So Natalia, we get a lot of different cases. We get GOMARs, we get boards, we get courts martials, we get AAIP. One thing that all of these have in common is most of them start with a command-directed investigation, right? Some 15-6 officer or investigating officer comes in and does an investigation into alleged misconduct. The most important aspect of those investigations is whether or not the respondent, the person who's under, or the subject who's under investigation, do they give a statement?
That's a great question. And I mean, in my opinion, it just completely depends on the case, right? Like you have to really understand what type of case it is before making that type of decision. There are definitely some cases in which it's in the best interest of the client not to say anything at all, and that puts the burden on the government to, prove whatever the allegation is beyond a preponderance of the evidence in a command-directed investigation. However, this is kind of an opportunity for the client to tell their side of the story and to tell it well. I think it's really important to have good counsel to help walk that tightrope, because it really is a bit of a tightrope walk. You have your narrative, your truth, what happened, which is always going to have something worth telling, I think. So it's just a matter of how to tell that compelling story without kind of stepping in it and maybe oversharing something that could be interpreted as an admission of guilt of something, while also kind of keeping in mind, the elements of what the government needs to prove and how you pinpoint those things so that when the IO goes to write their final version of events or their, final product, that they have a lot of facts that are on the side of the client.
Most of these IOs are not professional investigators, right? They're other officers who are tasked to do this investigation. They have no training, they've not done investigations, they've not taken statements, so they really don't know, for the most part, what they're doing. They get a legal advisor, but still, a legal advisor is not conducting that investigation. So your statement as somebody who's under investigation to that IO is probably the linchpin of how that investigation will go.
That's very true. It's a huge part of what they're looking at when they go to write their final report. And so it's so important to really just serve up all of the best information for your client on a silver platter to that IO, while keeping in mind all of the other things that you want to avoid to prevent complications later.
Yeah, well, obviously, everyone has the right to remain silent, not give a statement. That's a guaranteed right. And they also have the right to provide a statement. Should somebody under a command-directed investigation ever just waltz into the IO's office and say, "I'm here to talk"?
No, I cannot tell you the amount of times we have had to deal with that because we're hired a little bit late in the game. And there is nothing that I wish more that we could just rewind, time and give a good statement out of the gate, or choose not to give one at all based on whatever, the case is. But doing a statement and providing a statement that is haphazard, that overshares, that provides information that's not relevant, can really, really hurt a case. And a lot of times too, I had a case recently where the questions of the IO were actually misunderstood by the client, and the client provided an answer that became very problematic later on because they just didn't understand what was being asked. So we had to clean that up when it was time to kind of provide an additional statement and explain what the client thought was being asked, why the client answered a certain way, and to really try to kind of backtrack on some of the things that were said. And that's never advantageous. We want to, provide a good statement right out of the gate.
Yeah, one of the things that I've learned over the course of 30 years of doing this is even truthful clients with the intent to tell the truth, giving a statement without legal advice can oftentimes say things that either open the door for other investigations or are misleading, not intentionally, or sound misleading. And so good legal advice is paramount in giving a statement. For me personally, I never do a video statement. I never do an in-person statement. I ask for the IO to give us written questions. We provide written answers. If they want to follow up on those written answers with additional written questions, we'll answer those too, because you can control the narrative, as you said, with the written answers. And there's really no ambiguity there. Your client doesn't have the opportunity to start talking off the cuff and saying things and editorializing and telling stories. You just need to cut that out. One of the things I have also discovered is, having your client write a narrative and then us questioning about that narrative, because the client doesn't really often know what's important or what's not important.
That's very true. And that's something I do too. I think it's hugely helpful to have the client write down everything. Just tell me everything that you think might be important. And then you whittle that down to what's really going to impact the investigation. And there's really no need to provide information that's not going to help achieve the goal, right? Which is to make the investigation go away.
So what type of career impacts would an adverse finding in, let's say, an investigation have on someone?
Yeah, so it's going to depend on what the allegation is, right? But it could run the gamut from everything from losing your actual position to having something in your permanent personnel file that's going to follow you around for the rest of your career, essentially stunting your career from further progression, all the way to possible elimination from the Army, the loss of benefits, loss of GI bills. All those things are on the table. And I liken it to kind of dominoes, right? The command-directed investigation is the first domino. Once that first domino falls, you're looking at just consequence after consequence, and the further along you get, the harder it is to stop those dominoes from falling.
And one of the things I've discovered about statements is there's a lot of things that can happen in a statement, right? People can question why additional information wasn't provided. They can question, why certain answers weren't given in the original investigation or original statement. They can question why certain wording was used. They can question why the order of the answers, internal inconsistencies. There's a lot of things that go into a statement that legal advice is really critical for. And if I were to say the statement is the linchpin of the investigation is the linchpin of any subsequent adverse actions, right? I guess you can't really underestimate the stress and psychological factors that go into actually providing a statement.
No, I think that's very true. And a lot of people just have this need to fill silence, right? You're sitting there with an investigator. You already know you're flagged, that you have this allegation against you, and you're just trying to fill that silence with anything that you think could possibly, clarify what happened or provide information. But a lot of people get themselves in hot water for, like you said, a variety of reasons. And it's so important just to be able to sit down with counsel, write down, your narrative, and to concisely answer those questions in a way that's going to, make it very difficult for the government to find that, whatever they're alleging actually happened by a preponderance of the evidence.
Bottom line, don't give a statement without talking to a lawyer. We are the law office of Will M. Helixon. We are your warrior advocates. You defend the nation. We defend you.